Hello and welcome back to my YouTube channel. I go by the name of Dr. Heinz. Anything if you did not know, I'm happy to see you guys once again, and we're here to discuss another hot topic. Well, this topic has been going on for a while, and if you didn't know about it, it is regarding Ariadna Jacob and Taylor Lorenz. If you've been following me on my Twitter, you know how critical I am of Taylor Lorenz and how much I believe she engages in shady practices. But what really catches my eye this time is how she has handled the entire Ariadna Jacobs situation. And the reason why I say that is because I've noticed suddenly a couple of tweets that pretty much had her celebrating her motion to dismiss. A lot of people may not have known the reason why that was actually the case, and time has passed, so a lot of people may have forgotten that she actually posted on a Twitter page that the case that the bogus quote unquote lawsuit has been dismissed. Well, it's not the first time that she said that. She's also said it back in August, and when people were still talking about the lawsuit, that she was calling out the publication saying, oh, it's not dismissed and I'm sure you guys are going to report it. And of course you can see the conundrum here, because a month later, she goes on to say it's now dismissed. So we already know that Taylor Lorenz is not the queen of telling the truth or being factual in her, data. Just looking at how she handled the whole LawTube drama, in which she reported that Tug and Legal Bites were reached out for comments, but in fact she did not reach out at all. And I'm pretty sure I'm not gonna go into that case, but I'm pretty sure she got in trouble with her team, and there was quite a bit of hubbub regarding whether she has been dropped as a writer. I don't know. I'm not gonna speculate on it, simply because of the fact that I just haven't looked into it. But that's pretty much the gist of what I gathered around that time. So what exactly sparked this? Well, that's what I'll be going through with you guys today, because I don't think a lot of people know about this case. And I believe this is the one case that will expose, well, if it's not exposed already, that will finally be the final nail in the coffin to show who Taylor Lorenz really is. Honestly, every time I see Taylor's picture, I just think of her as a Spanish conquistador. I don't know, man. A Spanish conquistador's wife. I just can't take her seriously, in my honest opinion. I like looking at all of this and looking at how this has transpired over the years. I can't imagine how somebody who has grown up in Mexico, pretty much moved and migrated to the States when she was 5 years old with her parents, and built up this kind of career, and was finally receiving the props that that she was getting. This happens, and so it's sad. Let's get on to the statements in the motion to dismiss and the decisions for those statements by the judge. And I'll provide my individual commentary. Once again, not offering legal advice or anything like that. It's just a commentator. I'm just being a commentator here, and I'm trying to present this case in the best possible, fairest light, if you could say that. I'm gonna try and be as unbiased as possible when I'm presenting my take, and try and see both sides of the argument. But in no way in this am I going against the judge or anything like that, just giving my commentary on it. So let's go ahead. Okay, so this is the background of the amended complaint. We already know the background from the article that I just read, so I'm not going to read the entire thing. I'm just going to read the article. Includes numerous statements that Jacob alleges are false, that she had refuted to Lorenz prior to the article's publication. Now, I must note, I did see a video by Ahmed Dillon, I think on the 13th of October, and she said in the interview with Tucker Carlson that Taylor Lorenz sent her all these questions 5 hours prior to publication, and she, even in those 5 hours, Ariadna Jacob had sent her responses and proof, and she still went ahead and published it. So I just thought that's an important context here to put out. These statements include quotes from two former clients, Marcus Lynn and Justin Underhill, who lived in the Kids Next Door K&D influence house. If you don't know about K&D, you had no childhood, because trust me, that was the best show on TV. Number 3 was my favorite. Actually, no. Number 4. Who is the redhead? Who is the? I forgot the name of the red cap girl, but yeah, she was my favorite. But Susie, I think her name was Susie. Anyway, moving on. Statement 1. Olin was quoted as saying, "We went into this thinking we have brand deals weekly or monthly. We were expecting a quota where we could pay our half of rent through brand deals, but we weren't getting enough deals to cover our half of the rent." So let's look back into the article to further understand this, what's actually going on here. It says here, the deal was this: Ms. Jacob agreed to pay about half of their monthly rent of 18k. In exchange, the tenants would produce content and fulfill a certain number of brand deals obtained by the company. So that's the context. They had they had to fulfill a certain number of brand deals. That's why it's being, there's no specificity to what it is or anything it is. Anyway, it's a quote saying, "We went into this thinking we would have brand deals weekly or monthly." Mr. Olin said, "We were expecting a quota where we could pay our half of rent through brand deals, but we weren't getting enough deals to cover our half of the rent." So we're gonna now go straight into the decisions to see what the judge decided on this, and and what his reasons for whatever decision he may have made might be. This is the decision from the judge. Before reading the statement 1, I'm just gonna go to show statements alleged to be substantially true. The defendants first argued that the 10 of the contested statements are substantially true. Substantial truth is the standard by which New York law determines an allegedly defamatory statement to be true or false. A claim of defamation should be dismissed if the alleged statement is substantially true. Statement is substantially true if it would not have a different effect on the mind of the reader from which pleaded the truth would have produced. If fine and shaded distinctions must be drawn and words pressed out of their ordinary usage to sustain a charge of libel, no legal harm has been done. In analyzing a claim for defamation relating to a publication, the entire publication and the substances of its issuance must be considered. From what I'm understanding of this, let's say for example, the substantial truth in this case would be, look, listen, I was with this person for X amount of, I was with this person for 5 years, and they were abusing me all through the relationship. Like I had to call the police on them, and all of those things. Like it was not pretty. I was really a victim of domestic violence. Things like that. He would give a different idea if that wasn't true and would need further corroboration. End of the day, substantially true doesn't actually mean it's the literal truth. It's just what can the reader infer from what I'm gathering. I could be wrong. Most likely I am. Sue me. Don't actually sue me, please. That's an expression. That's an expression. So anyway, so he says the court will address each statement in turn. Statements regarding K&D. Statement 1 is Olin's quote that the K&D residents were expecting. Wait, is that a typo? Okay, so that's a typo. Okay, statement 1 is Olin's quote that the K&D residents were expecting a quota of brand deals where they could pay half their rent. We just read that. The defendants argue that this statement is true because prior to publication, plaintiffs had informed defendants that the K&D residents were required to pay their share of rent, and that influencers had exclusive control of their contracts, meaning influencers were solely responsible for procuring deals. The plaintiffs respond that their pre-publication communications confirmed that the agreement did not guarantee a certain number of deals. Having reviewed the parties' pre-publication communications and the article, the court finds that the statement is substantially true. The article does not specifically say that the plaintiffs had promised a quota, but rather that the K&D residents had expected enough deals to cover rent. Therefore, statement one cannot be the basis for a defamation claim. Honestly, I agree on this one, because it is a technical wording that just changes the whole theme of it. Even if there is a contract in place that says, okay, you have to get a certain number of quota in the industry itself. You like, no matter where you are, if you are in the entertainment industry, unless you are someone like Usher, for example, who in their heyday can bring you a guaranteed amount, and the agents would negotiate a guaranteed payout, something like that, or someone like Jay-Z, for example. Unless you're like those kind of titans, a lot of the deals is can I say contingency based, or really dependent, or really dependent on how much you would sell. The point I'm making here is, I know that one is more of payment in regards to sales, etc. I understand that. The point I'm making here is from a manager point of view, signing in this case a TikToker, and they were promised, okay, we can get you this brand deal, this brand deal, this brand deal. It would be, for the manager, it would be a real big shot in the foot for them, without really knowing what they can bring to those brands. For example, without really knowing their impact, or to use my example a bit more loosely here, you're more likely to find a manager saying, look, I've got this deal with Adidas, Nike, Adidas, Nike, Hugo Boss, etc. I've got these deals for you, 4 deals for you lined up, Drake. If you sign with me now, I will get you 20 million. They're all lined up. I will get that for you if you sign with me. That's completely different to someone who is unknown. They were like, look, listen, I can get you these deals, but we need to work and do this. From what I'm seeing from the article that we just read, it would make more sense that she's offering that type of deal where they'll work and get these deals in place. It's not as if they were quote unquote titans in their industry. They were coming up, and they were being managed to be propelled and be made into bigger stars than they were rising to be, if that makes sense. So that's the reason why I'm like, I understand where the judge is coming from, because expecting to get a quota to cover their share of the rent isn't actually a bad. It is like they entered into a contract. It is a reasonable expectation to have. It's not as if they were promised a quota and then that would have to be investigated for example. But just by having expectations, that's not defamatory on its face. Let's go back to statement. So statement 2 was, Underhill was quoted saying, we didn't have working Wi-Fi for a month. We couldn't go live. We couldn't go live because our live streams would cut out. The plaintiffs alleged that Underhill had financial struggles, not because of any actions by Jacob, but rather because of his account suspension due to failure to follow user guidelines, a fact about which Lorenz was made aware. So let's go back to the article again and see what it's. So let's go back to the article again and see what it says. It says here, that wasn't all. We didn't have working Wi-Fi for a month, said Jesse Underhill, 22, another member of the house. We couldn't go live because our live streams were cut out. He struggled financially after moving into the house. I used to get 3 to 5 brand deals a week. Mr. Underhill said, since I moved in one every 2 weeks, and they are lowballing. So this one is a bit, from what I'm reading from the article, this one is a bit more, it may be in ranges, but it's a bit more defined than Olin's statements. Let's go and see the decisions that was made in regards to this statement by the judge. So it says here, statement 2 is a quote from Underhill that the K&D house didn't have working Wi-Fi for a month, impacting the residents' ability to live stream and ultimately leading to financial struggles. The plaintiffs argued that the phrase working Wi-Fi wrongly suggests that it was the plaintiff's responsibility to provide Wi-Fi. However, as the defendants have pointed to no evidence of their statements, substantial truth in the pre-publication communications or otherwise, they have not shown that these statements are substantially true. Accordingly, the court must further analyze statement 2 to determine if it survives the motion to dismiss. That's fair. The defense didn't argue against it. It is what it is. So let's now read statement 3. It says, at the end of July, the influencers were told by plaintiffs that they would have to cover the larger share of the rent at the K&D house. They all felt the crunch, and the dream of living and working in a mansion with friends turned into a living nightmare, Mr. Andio said. By early August, half of the residents had moved out. The house itself has been relisted on relisted for sale on Zillow. The plaintiffs alleged they merely demanded compliance with the influencers' contractual obligations. Yeah, so basically all of statement 3 is basically in the article. Is basically all that we just read. So we're just gonna go straight on to the decisions and see what the judge has said. So for statement 3, the judge ruled, statement 3 is that the influencers were told at the end of July 2020 that they would have to cover the larger share of the rent, turning their dream into a living nightmare as described by Underhill. The defendants argue that this statement is true because in plaintiff's pre-publication communications, they stated that Jacob had told them they would need to pay more rent. The plaintiffs respond that they did not admit this, but rather stated that that they had been letting the K&D residents slide, quote unquote, on paying their rent, but when the breaches of their obligations were discovered, required full payment of their half of the rent. Having reviewed the communications, the court finds that neither of the parties' positions are supported. The plaintiffs did not state that they had paused payment obligations and only resumed them upon discovery of agreement breaches, nor did they state that they had increased the rent. Rather, the plaintiffs stated that the kids were asked to actually pay their share of rent and expenses per the terms of their agreement. Therefore, it is not clear that this statement was substantially true, and the court must further analyze statement 3 to determine if it survives the motion to dismiss. That's fair. I think there is a lot going on in there. There's a lot of moving parts. If you go back to the statements again, so we could see that that in here there's an allegation there that they were told that they will cover their larger share of the rent, and they had to move out as a result for not being able to meet this. So from what the plaintiffs allege, there is enough here, not just from the face of it alone, there is enough there to actually say, look, we need to further analyze this because there is a bit more to this. Now moving on to Brittany Tomlinson's statements. He goes on to say statements regarding Brittany Tomlinson, a TikTok creator who would later become plaintiff's clients. So statement 4 reads, Jacob had messaged Tomlinson via Twitter direct message, asking, I'm seeing this image of you going around a lot. Have you made any money? The plaintiffs allege that messages demonstrate that this was false, and defendants did not ask the plaintiffs about this prior to publication. The plaintiffs allege that this statement sets a tone to portray plaintiffs as unethical and unscrupulous, demonstrating defendants' reckless disregard for the truth. Now let's go on to the article to actually get the full context of it. This is the person, I believe. This is Brittany Tomlinson, who is the person making the statement in regards to the DMs. Let me read from here. Also, Miss Jacob's client at the time, Brittany Tomlinson, whom Miss Jacob had approached after a video of her reaction to a taste of kombucha went viral. Quote unquote, Ari DM'd me on Twitter and was like, I'm seeing this image of you going around a lot. Have you made any money? Miss Tomlinson, 22, said. She said that Miss Jacob told her she owned an ad agency and could get a deal with a kombucha brand. All Miss Tomlinson needed to do was sign a contract. That's enough right there for me to say that there is a lot more going on here that should make this statement alone survive and survive the motion to dismiss. But let me see what the defendants argue or what the judge decided. So for statement 4 decision, it fell under no defamatory meaning, and it goes on to so this was for statement 4, 5, 7, and 13. Go on to read that. It says no defamatory meaning. The defendants further argue statement 4, 5, 7, and 13 are not capable of defamatory meaning and should be dismissed. As the second court as the Second Circuit has explained, a plaintiff in a libel action must identify a plausible defamatory meaning of the challenged statement or publication. If the statement is susceptible of only one meaning, the court must determine as a matter of law whether that one meaning is defamatory. If the words are reasonably susceptible of multiple meanings, some of which are not defamatory, it is then for the trier of fact, which would be the jury, or if it's a bench trial, that would be a trier of fact, not for the court acting on the issue solely as a matter of law, to determine in what sense that words were used and understood. So on its face, it's telling you if it has more than one meaning, it should go straight into straight to be decided outside of this motion to dismiss. But if it doesn't, the court can decide whether it survives or not, basically. From what I'm understanding, could be wrong. Correct me if I'm wrong, anyone who's watching. So it says a statement is defamatory if it exposes an individual to public hatred, shame, obloquy, contumely, odium, contempt, ridicule, aversion, ostracism, degradation, or disgrace, or induces an evil opinion of one in the minds of a right-thinking persons, and deprives one of confidence and friendly intercourse. I wish it was discourse. I really wish. But anyway, a friendly intercourse in society. My mind is so dirty. It's unreal. Pause. Oh Lord. Yeah. So it goes on to statement 4. He says statement 4 is that Jacob messaged Tomlinson to ask if she had made any money after one of Tomlinson's videos went viral. The plaintiffs concede in their response to this motion that this statement is not defamatory in itself, and they include mention of it in the complaint to show that the article as a whole created the false gist that the plaintiffs acted unethically. The same is true for statement 7, quoting experts describing what generally occurs in ethical silence agreements. Such statements are not susceptible to defamatory meaning of their own. Accordingly, any defamation claims regarding statements 4 and 7 are dismissed. We already get the idea here that there was not, from the definition that they gave in regards to a defamation claim, as well as what the defamatory is to the meaning, which is exposes individual to public, etc. Reading the statement in of itself, I can see why they had to concede to that, because there wasn't really enough even in the statement on the face of it to even suggest anything of the sort. She DM'd me and this was what was happening. I get the argument, but it was kind of weak in my view, in my honest view. I'm going to read statement 5 here. It says, statement 5 goes on to say, Tomlinson flew to Los Angeles in 2019 and stayed at Jacob's apartment. The article states Jacob is buying me lunch and dinner. She claims she is mentored by Gary Vee, and said, Miss Tomlinson, referring to the entrepreneur Gary Vaynerchuk, I met all these people who said will help my career. Mr. Vaynerchuk said he has no affiliation with influencers. The plaintiff alleged that this was misleading, as mentorship is not the same as affiliation, and Vaynerchuk even offered Tomlinson a spot in the Super Bowl commercial because of his relationship with Jacob.
Where's Ari?
Right here.
There she is. Okay, great. Well, we're really excited that we were able to put this together. Gary and I have both known Ari for a very, very long time. We're huge fans of everything that she's up to out there and just her as a human being. So we're excited we're getting to do this.
And thanks for that. I mean, I asked that question because, I was working with a lot of the huge people, and I think these guys are the next sort of crop of talent. And I think, it's good to know that that type of challenge is similar to what we're experiencing. But I think a lot of people here are super excited to have the support of a company that's supporting them in this way.
Yeah, I mean, are you in this, even on a block? Like, what your job is to bring enough value that they think it's better to be with you than somebody else. That's what the fucking company is.
Let me tell you what's cooking. We are doing a Super Bowl spot, and we are in control of the talent, and we want to go high-low, 1980s, 90s nostalgia, and then emerging faces in social. And to be very frank, because of my relationship with Ari, I want to help my friends through this, and I think Brittany has caught a cultural enough moment, and I think the fact that she would be in a Super Bowl spot would change her career, because then that would open up every brand deal. And not that it's approved yet, but I've got it on third base. We'd like to offer Brittany to be a part of it.
That's very interesting because let's go back to the article to actually read it. It says Miss Tomlinson signed a non-exclusive agreement with Miss Jacob in August 2019. A month later, she signed a new contract, making the arrangement exclusive. Miss Tomlinson flew to Los Angeles in September and stayed at Miss Jacob's apartment. She's buying me lunch and dinner. Quote, she claims she's mentored by Gary V, said Miss Tomlinson, referring to entrepreneur Gary Vaynerchuk. I met all these people who she said will help my career. Mr. Vaynerchuk said he has no affiliation with influencers. Now, I already said that this enough is a wild claim. It is honestly, it is very misleading. I do actually agree with the plaintiff on that one, because anyone that knows anything about affiliation, just because the person did say, oh, you're getting mentored, does not actually mean, does not turn around to mean that that you're getting mentored, that you're affiliated now with the brand. It's like trying to prove a negative here. You can't really prove that affiliation, say, just by that mentorship. Like, being affiliated with somebody means there's a signed contract there, etc., and all of that. So for you to be making the allegation, and for obviously Vaynerchuk to now say, no, we're not affiliated with the brand in any way like that, could be for so many reasons. It could just be like, it could literally just be, I'm setting the record straight, we are friends, but Vaynerchuk Media or me yourself do not deal like that, if you know what I'm trying to say. So that's what I'm getting from this. Let's see what the judge ruled on regarding this claim. So it says, Statement 5 states in part that Mr. Vaynerchuk said he has no affiliation with influencers, following Tomlinson's statement that Jacob told her she was mentored by Gary Vaynerchuk. While the plaintiffs argue that the statement implies that Jacob lied about the fact of Vaynerchuk mentoring her, the court disagrees. So they okay. As the defendants argue, the parenthetical means exactly what it says, that Vaynerchuk is not affiliated with influencers despite any association with Jacob. Accordingly, the defamation claim as to Statement 5 is dismissed. I actually, for this statement, I get it. In my honest opinion, I really do get it, because it would be a splitting hairs argument, affiliation, no affiliation. But on the whole article, the way it does look, it really makes her look like she is a liar. Like, not just a liar, but a dirty business practice that would lock you into a contract and then say, and then make it out to be, oh, I had a mentorship with this person, so therefore, this person can do you this, or do this for you because they're affiliated with me. That's the impression that that you would get from the article. Like, oh my gosh, she's a quote unquote beg to be going this far to try and sign this person. So on a whole, I do understand why the statement is dismissed, but on a whole, it does give the gist of this being a person who practices unlawfully, if you should say. So this is going back to this. It falls under the defamatory meaning. So it's statement 2 regarding the Wi-Fi. Let's just go through it really quickly. It says, lastly, the court also dismisses statement 2 Underhill's quote regarding lack of Wi-Fi, leading to financial struggles. As it's fine, there is no potential defamatory meaning to the statements. The quote does not refer to the plaintiffs as the cause of the Wi-Fi problems. Accordingly, statement 2 is dismissed. So if we remember statement 2 in regards to the Wi-Fi, we just go ahead straight away. It's just basically handling that part, and we read the other side of it being accepted. I believe that one was accepted. So let's go on to statement 6, which says, quote, by January, I realized I hadn't been paid since Halloween, Tomlinson said. Ms. Tomlinson reached out to the brands she had worked with and discovered that she was owed tens of thousands of dollars. In April, she filed a complaint with the California Labor Commission on the grounds that Ms. Jacob had violated California law by operating with a talent agency without a license. In it, she claims Ms. Jacob is withholding $23,000 in fees. I'm not going to read the exact number because it's just a lot, but $23,000 in fees that Ms. Jacob demanded unconscionable. I can finally say it. I was struggling with this word for so long, but demanded unconscionable fees of up to 20% commission that Ms. Jacob bought and is squatting on the domain name BrittanyBroski.com. That's a lot there. The plaintiff alleged that Tomlinson was not signed to Influences, as this statement suggests, but rather Creator Edge, another company in which Jacob was 1/3 owner. Further, the fees were not withheld, but simply had not yet been paid by the brands. Okay, so I'm not going to go back and read the article. It's pretty much the same thing that has been quoted in the statements here. But I will say this before I go on to read the judge's decision on this statement, that this should survive on its face. I mean, there's so much going on in there that you just can't say this is substantially true on its face. It should really survive, in my honest opinion. Just the fact that you are alleging that she doesn't have a license to even be a talent, to even have a talent agency is just wild to me. That requires investigation. But let's go and see what the judge says. So the judge here rules on statements regarding Tomlinson. This is for, again, the substantially true standard. Statements regarding Tomlinson. It says the plaintiffs allege that statement 6 is false and defamatory because, in part, Tomlinson was signed not by Influences, as the statement implies, but rather by Creator Edge. The defendants argued that the statement was true because Tomlinson's agreement shows that she was signed with Creator Edge Inc., DBA Influences, and Jacob executed the contract herself. The plaintiffs already conceded that this issue and instead focused their claim on the portion of statement 6 wherein Tomlinson is quoted as saying that in January 2020 she had not been paid since Halloween 2019. The plaintiffs argue that this statement implies that plaintiffs withheld money from Tomlinson, when in fact it was the brands that had not yet paid. However, the article does not state that the plaintiffs were the cause of the non-payment. That's a fair argument to make. Rather, it states that Tomlinson reached out to the brands she had worked with and discovered that she was owed tens of thousands of dollars. Neither party disputes the truth of the portion of that statement, and it provides the context necessary to demonstrate that the previous statement about not being paid is substantially true. Fair enough. It wasn't the plaintiffs that was responsible for the non-payments. They did say it was the brands that didn't pay her. Makes sense why this would be true on its face. Hey, the brands may have paid her and she still lied about it, but in terms of the plaintiffs versus defendants, it's substantially true. They both agreed to it. They both didn't really argue differently. So so it would be substantially true in that case. I'm just bringing out there that it could literally just be a lie that the brands did actually pay her, but she just wanted to put this in the article. But there's nothing to doubt. While the next sentence is to discuss Tomlinson's complaint with the California Labor Commission, in which she alleged that Jacob was withholding $23K. At least the judge cannot read the exact amount as well. At least we can agree on that one. Anyway, the statements do not collectively imply that the plaintiffs withheld payments from Halloween to January. Accordingly, the statement is substantially true and claim relating to this statement 6 fails. I mean, I don't agree with this. I really don't agree with this, simply because of the fact that I get it. It was specific. They were expecting payments. It was being withheld, but the fact that these are two separate things going on. In my honest opinion, there are two separate things going on here. Okay, there is withholding payment. That's fair. You can dismiss that claim. I understand, but there is also another claim in there, which is the fact that she does not have a talent agency license to even be a talent agent. She cannot basically practice without this. That in itself, I think, is defamatory to a point that it would send a message and give a different impression, different meaning, degradation, same, whatever. It wouldn't be substantially true because it would require investigation. It will cause someone to think differently. So based on the substantially true standard that we read about, this statement you can dismiss the rest, but I feel like that part should have stayed in, because there could be truth to the Labor Commission, as in just like, hey, look, I got my license, here it is. She's lying and this is being defamatory. You understand what I'm trying to say? So that's what I'm getting from this. I don't necessarily agree with this decision. I do think the way that the judge argued the first statement is consistent with this last statement about withholding money. The reason why the judge even dismissed this as well is because it didn't imply that the plaintiff was being withheld from Halloween. It seemed flimsy to me, because you can dismiss, okay, fine, you can dismiss the withholding part for not implying that she was withholding, but the Labor Commission should have stayed in my honest opinion. So going back to the statements, would be statement 7, and it reads, quotes from other talent managers regarding allegations that Jacob tried to lock creators into contracts. In an ethical management talent relationship, you should be able to part ways at any time, said Lisa Filippelli, a partner at Select Management Group, a digital talent management firm. Any management contract with a creator should be at will. Less mature companies have manipulated what the word signed means. Chris Chastal of Right Angle Management said that forcing a client to stay when their relationship with a manager has sourced is unheard of. Trust in the relationship is so key, he said. Without that, you can have all the paperwork between the talent and the manager, but if you don't have the trust in place, it's not going to work. I think reading the statement itself, I think I have already read this in the article, so they have quoted the full thing, but I think it's important to revisit it a little bit because of the way that Taylor has sandwiched it into this case. It says here, Miss Jacob has conducted herself with the almost professionalism and courage in the face of individuals who attack her both personally and professionally. These individuals attacking her don't want to play by the rules of decent individuals in society, but want to attack Ms. Jacob publicly from the shadows, talking to any individual who is willing to listen to them, said Ben Walter, a lawyer for Ms. Jacob. Now, the way it's sandwiched, I mean, we've just read this, so I'm not going to go through it, but the way it's sandwiched into this, it makes it seem, just on the next statements alone, it just makes it seem as if it's damage control, even though you can read and say, oh, that's Taylor Lorenz trying to be fair and present a well-balanced argument. That's the point, because the way she's sandwiching all of it, it doesn't look like a well-balanced argument. It just looks like someone who is going on a damage control and is trying to say these people are bad, they're saying bad things about me, it's not true, etc. And it's making it seem like what any unscrupulous person would say based on what has been covered so far. So sandwiching it here already looks, it looks really underhanded, in my opinion. Nonetheless, we already know that statement 7 was dismissed with statement 4 for having no defamatory meaning in all of it. So there's no real reason to keep looking over this statement, and we're going to move on to statement number 8, which is statements regarding the girls in a valley GIV influencer house made by influencers. Statement 8 goes on to read, quotes from Tiana Singer, a TikTok content creator whom the article claims was managed by influencers, and her mother, Salam Singer. She promised brand deals, money, and opportunities. Ms. Singer said everyone was promised income, but that never happened. Salam Singer didn't expect things to devolve as quickly as they did. She described Ms. Jacob's behavior in the end as shameful. It is a very predatory environment. Ms. Singer said of the industry, you have a situation where you have young, vulnerable people with the potential access to a lot of money. Then you have older people who are going to take advantage of the situation. Tiana is not going to be the first or the last. So we're going to take a look at the article, because there are parentheses that does separate to the quotes that was considered defamatory, and I feel like that needs to be addressed so that we can get the full context of what's actually going on with this statement. Okay, so let's read from this part of the article, which says, Ms. Jacob also said she wanted to protect creators from mistakes in the industry, the ugly part of Hollywood. None of the creators who have left influences were harmed, she said in the statement. Instead, some received a free rent, a spot on a Super Bowl commercial, we know who that is, trips on jets, private estates, professional publicists, and mentoring from the best in the business. We know again who that is. None of them have yet been sued, and we have not hindered any of their careers in any way whatsoever. Again, looks okay on his face. Looks like Taylor Lorenz is being objective. Not really, because the next part is what I'm talking about. Tiana Singer, 19, moved into the Girls in Valley house, also managed by Ms. Jacob. In late May, she promised brand deals, money, and opportunities, Ms. Singer said. Everyone was promised income, but that never happened. So we know that that this is Ms. Singer's individual statement. Now gonna go down and read. That's Tiana Singer here, and this is the part of the statement that was in there, which is here. It says it's a predatory environment. We know that's there, but this is the context. And he goes on to say, parenting in the influencer age. By the time Tiana Singer was unpacking her bags at the Girls in the Valley house, her mother, Salam Singer, was already nervous. She wanted to give her daughter some autonomy, but worried about the contract Tiana had signed and the amount of oversight Ms. Jacob would be providing. You need a lot of structure, and you're dealing with young people, Ms. Singer said. They're basically foregoing college and going into this like a career. So they would need guidance, and they would need to be told when to do that. To do what? Ms. Singer didn't expect things to devolve as quickly as they did. She described Ms. Jacob's behavior in the end as shameful. It's a very predatory environment, Ms. Singer said of the industry. You have a situation where you have young, vulnerable people with potential access to with the potential to access a lot of money. Then you have other people who are going to take advantage of the situation. Tiana is not going to be the first or the last. So we can see how on the whole that paints a very, very different image to, it does appear as a hit piece. It appears as so many blows going to Ariadna Jacob's way, and she's just trying to deflect as much as possible, but it looks like she is really a really bad business person, and she's holding these people hostage. So let's go and see what the judge decided regarding this statement. So this statement actually appears in substantially true as well as hyperbole and opinion. But let's go and read the substantially true statement first, which was statements regarding GIV. Statement 8 is a quote from singers that Jacob promised brand deals, money, and opportunities. Again, the defendants argued that plaintiffs' pre-publication affirmed that they had promised those they represented brand deals, money, and opportunities. However, as plaintiffs argue in response, and as the court confirms, the pre-publication communications do not address the issue of whether plaintiffs had to provide these opportunities to their clients. Therefore, it is not clear that this statement was essentially true, and the court must further analyze Statement 8 to determine if it survives the motion to dismiss. This is fair. This is very fair because if we go back to Marcus Orlin, that was expectation, and this one here is a promise for something to happen. You can get a lot of a different thought here if you say they broke that promise and they didn't. You can all those things. So it does deserve further analysis. So for Statement 8 as well, for hyperbole and opinion, it says Statement 8 is quotes from singer's mother that Jacob promised brand deals, money, and opportunity that never happened, leading to shameful behavior by Jacob as the girls ended up moving out of the house. Further, singer's mother explained the potential for a predatory environment in which young vulnerable people with potential to access a lot of money interact with older people who are going to take advantage of the situation. She concludes Tiana's is not going to be the first or the last. The defendants argue that these statements are opinion. At least one court in the district has held that similarly hypothetical statements are not defamatory, holding that which is C Small Bus Bodyguard versus House of Monksy Inc. That case was basically saying, holding that a statement describing events as including varying degrees of what many people might view as extortion, manipulation, fraud, and deceit by someone I know was not defamatory because 1, the plaintiff was not named in the statement, 2, the statement cannot be proven false, and allegation is too loose, figurative, or hyperbolic to be actionable. However, here singer's mother does identify the plaintiffs and states that Jacob promised brand deals, money, and opportunities, and that can never be proven. That never happened can be proven false. While hypothetical comments regarding taking advantage of vulnerable young people are not actionable, the central statement that plaintiffs made promises that were not kept is actionable. It's quite simple on the face of it. You cannot say I promised something and say, oh, that's an opinion. It's really it was a losing argument to actually begin with, but you can't fault them for actually trying. You can't fault them for actually trying. Also, I noticed in there that Statement 7 was also part of the hyperbole and opinion as well as Statement 3. I didn't go through them. I'll just quickly run through them now. It says Statement 7, the expert opinions on what ethical management talent relationship looks like is even described by the plaintiffs in the complaint as opinion. The plaintiffs concede that it is non-actionable in itself. Accordingly, although already dismissed above as having no defamatory meaning, it is also dismissed as an opinion. Makes sense. It would be an opinion. Okay, so Statement 3 here, it says Underhill's quote that living with friends became a living nightmare. Such statements have been dismissed as non-actionable opinion or hyperbole. and they cited the case for it, which is Maron versus Pyro, year 2020. It says, dismissing the statement made in context of rambling monologue that a house was a nightmare. The court and even plaintiffs agree that this statement is not actionable. However, it is preceded by the statement that Jacob told K&D residents that they would have to cover a larger share of the rent. The portion of Underhill's statement is neither hyperbole nor opinion and is susceptible to defamatory meaning, as it could suggest that Jacob acts unfairly and by surprising our clients with burdensome terms. Therefore, it will not be dismissed on this basis. So it wasn't dismissed as hyperbole and opinion, and that's why it survived the motion to dismiss in regards to substantially true, I guess. So now we're going to go back to the statement and read statement 9. It says, Tiana's housemate said that Miss Jacob put a lot of pressure on them. She would show up at all times of the night. Miss Singer said she will come as late as 1 a.m. and she'll be texting us until 3 a.m. and she'll back up at 10 a.m. She will bring guests with her without telling us. There was security camera in the kitchen of the house, which Miss Singer said was installed without our consent and connected to Miss Jacob's phone. Miss Jacob said that the cameras were installed by the property owner for security purposes. The plaintiffs alleged that Singer was not managed by influences, but rather was allowed to stay in the GIV house in exchange of signing a release of liability and non-disclosure agreement, which included a provision agreeing to the security camera. The plaintiffs alleged that Lorenz never investigated or asked about this issue, or else plaintiffs had refuted the information to Lorenz. Not just that, also, from what it sounds here, it just sounds like a normal... I know I shouldn't say this is normal, but it really is, because in the entertainment industry, you really must be on your grind. And in all fairness, it just sounds like someone who didn't want to do all the work and found it a bit, I wouldn't say demanding, but found it not necessary to improve our brand. If you are told, if like for example, I used to run events, I used to DJ and put my own events on, and I would have my team of ticket sellers that would need to sell tickets pretty much every day. It's not a 9-to-5 job as many people might think. I, in my own experience, would literally get an idea, or I've created a promo video that will be used to promote and help with push the sales of the ticket. This video, I'll be sending it to my team, even if it's 4 a.m. You know what I mean? Saying, hey, listen, get this ready, post at this time. We need all hands on deck on this one. Or even if I was to get a tweet from, let's say there was an act that was booked for one of the events, and we had to tweet about this act. I believe this was one of the events I was DJing at, and what was it, Creton Conan? I think it was one of those acts that was meant to appear in the uni, and they were doing tweets, and the manager itself was sending us messages literally at 1 a.m. And telling us to retweet these tweets even at that time, and to also retweet in the morning as well, and to really push out this so that it can help ticket sales, because it's tweets from the artist. You don't sleep in this industry. That is what I'm trying to say. So from what I'm reading from this, it just sounds like she was an entitled quote-unquote brat. But let's go and see what the judge decided on this case. So statement 9, it falls under substantially true, and in statements regarding GIV, it says statement 9 is Singer's statement that Jacob would arrive at the GIV house late at night, text them late at night, bring guests without notice, and install cameras in the house without their consent. The defendants again argue that plaintiff's pre-publication communications confirmed this event. There was one camera installed in the kitchen in July for the safety of the individuals living there. Each individual was informed about the cameras. Jacob runs a business that requires her to work 24/7. Jacob brought guests into our house. These communications do establish the substantial truth about the portions of the statement regarding the texts and guests, but do not establish the substantial truth of statements regarding the installation of the cameras without consent. What? Okay, because Jacob stated that they were informed about the cameras, therefore, portion of statement 9 referring to installation of the cameras must further analyze. But the claim as the remainder of statement is dismissed. So wait a minute. There is inconsistency here from the judge. Remember the previous statement, I believe it was statement 6 from Tomlinson regarding the non-payment and the license I was talking about earlier. This is basically my point. How does he recognizes that if you're going to allege that cameras were installed, we're going to need to dig a bit deeper, because that does have a broader meaning. It does send someone's brain into a haywire. So even though you confirm the other events that he was visiting them late at night, that there were texts, etc., all those things, that's fine. You can dismiss that, and it may not send the idea of that's weird, because like I said, it is industry practice. You would get those texts at night. People reading that, knowing the industry, or even without knowing the industry, a reasonable mind would think this is just work. It's what you're supposed to do. But the camera installation, for a fact that needs further analysis just by the face of it. Why that didn't apply to the Labor Commission as well is beyond me, because those are two separate statements, and the judge rightly separated these statements. So again, the consistency is lacking here, because if you're going to dismiss the other statements outright, you should dismiss this one. And to be honest, I think he knows if he dismissed this one, it will be an error, a legal error. So that's what I'm pointing out here. Like, if the Labor Commission was a separate statement, this one as well is a separate. There are two different things happening within that you can't dismiss the whole statement like he dismissed the whole of statement 6. I just thought I'd say that. Let's go back to the statements again and read on with statement 10. It says here, statement 10 says, the creators in the house said that on June 7, Ms. Jacob told them that they would be thrown out if they didn't post on social media at least 8 times a day. The plaintiffs allege that this is false, as the residents were asked to leave because of failure to honor their contractual obligations, ethical violations. Specifically, Singer was asked to leave due to hosting parties during a COVID-related quarantine, underage drinking, and becoming a deadbeat influencer who did not generate results. Like I said, it just from reading her previous statement in regards to the late at night, all those things, I agree with Ariadna Jacob here, because come on, it's like, for example, put a video on YouTube, for example, or even TikTok in this case. Put a video there and do not promote it, do not touch it, do not do anything, just leave it there. Who is gonna know about it? Like, you need, in that industry, especially, you have a manager that is known for marketing, you know what I mean, that is known for doing this. How do you not think that she is going to be on your case to meet these targets? You know what I'm trying to say? 8 to 10 social media posts you cannot even do? Are you kidding me? Like, it just seems like a prima donna, like, kind of thinking. Personally, on the face of it, I don't think it's strong enough to actually survive this claim, in my honest opinion. But if I could anticipate anything, it would go to show that the whole article is trying to paint her as someone that is just unscrupulous, demanding, and just unreasonable. You know what I mean? So, but I personally, I'll be surprised if the judge does keep this on and make it survive. But I do think, even though I say that, I do think it does warrant a little bit of investigation to into the business practices front, and it should survive on that front. But I'm not holding my breath is what I'm trying to say. Here is the judge's decision on statement 10. It goes on to read, statement 10 is that Jacob required the GIV residents to post 8 social media posts per day to continue living in the house. The defendants argued that plaintiffs confirmed in pre-publication communications that residents needed to create and post a certain number of contractual social media posts or else would need to leave the content house. The plaintiffs have not disputed this argument, and the court agrees that the communications established statements substantial truth. Therefore, the defamation claim as to statement 10 is dismissed. Okay, I understand that. I didn't think on his face it was strong enough to survive. I do think it does create an impression, but I mean, let's just talk about it for a minute. 8 to 10 to keep living there, of course. It's like, I mean, I've DJ'd in Napa, and I had to sell tickets for some of the events that I've DJ'd at, and literally the target even then was only 5 tickets, like to sell. Obviously, I was just a DJ, and there was even this conversation of whether DJs should sell tickets or not. But getting to play in Club Ice, like, you know, the biggest club, and warm up for a house DJ that was really big on the underground scene in the UK, was a really big feat. Like, it was, you know, you kind of have to work to get it because I was not known. So just by that example alone, and I'm like, you have to post 8 to 10 times a day and you can't even do that. That's not even selling. Like, I had to go out of my comfort zone to actually secure something. Personally, I sold 15 tickets, but the target was 5 a day. But I mean, overall, I sold 15. It was done in a week. And if you want to put 5 a day, this and that, I should have sold more. But again, the target was sell five tickets or more. It wasn't basically by day. You know, I'm messing up the explanation that I'm giving. But the point was, the target was 5 tickets a day, and I was out every day selling these tickets. And you can't even post 8 to 10. I don't know, man. That's just weird to me. That's just weird. Why are you in the industry then? Like, it's what I'm saying. Why are you in the industry? So anyway, moving on. Let's go back to the statements, and it reads. Statement 11 reads, we were often very intimidated by by Jacob because the conversation became explosive, said Ms. Singer. In mid-June, Ms. Singer and others left the house. They described a hectic move-out day that involved an escalating verbal fight with Ms. Jacob, which resulted in several calls to local authorities to intervene. The group documented the day's events on Instagram stories. Ms. Jacob said she asked not to be filmed, but she recorded the events too. In an email from her lawyer, Ms. Jacob denied the fight that a fight took place. The plaintiffs alleged that defendants knew these statements were a lie because they knew it was Jacob who had called the authorities twice on the results as a result of their threatening behavior and vandalism. I must say, I'm not surprised she's even alleging that they argued. I'm thinking in my head that the argument was, why are you not posting? And she's like, I don't want to post. Like, that's just what I'm thinking the argument is. Nonetheless, I mean, I'm not gonna go back into the article to try and examine this. I think we got the idea here what's going on. Let's just go straight into the judge's decision on the statements. So statement 11 goes on to read. It says, statement 11 is that, so here's the judge's decision regarding statement 11. It goes on to read, statement 11 is that when several GIV members moved out of the house, there was an escalating verbal fight with Ms. Jacob, which resulted in several calls to local authorities to intervene. The defendants argue that this statement is true, as confirmed by the complaint itself, in which the plaintiffs allege that the influencers were aggressive and threatening, resulting in Jacob calling the authorities twice. The plaintiffs argued that article's description implies that it was the influencers who called the police regarding Jacob's behavior, but do not dispute the statement's literal truth. And accordingly, the statement is substantially true, and defamation claim as to statement 11 is dismissed. I mean, it will be a splitting hairs argument. Okay, you call the police, they call the police. It doesn't matter. Police were called. You admit that they were being threatened, etc. I get the idea that they're trying to paint you as a bad guy in the article, but I mean, it was gonna be a very hard statement to actually, win by. So let's go back and read the rest of the statements. It says statements regarding the Drip Crib influencer house. Statement 12. Statement from Devion Young, a former client. She manipulates you. It's a nightmare, Mr. Young said. She said that she used nude photos of his to shame him. Right before we parted ways, she leaked my nudes and sent them to business partners, people in my house, and potential investors to slander my name. Saying I was unprofessional, Mr. Young said Ms. Jacob informed an internal consultant of the picture's existence. Ms. Jacob's lawyer wrote and clarified that she did not publicly leak the photos. The plaintiffs alleged that the implication that Jacob did leak the photos is false because Young told Jacob that the leak of his nude photos had nothing to do with her. So that's what the lawyer meant by she did not publicly leak the photos, because it meant it was not her that done it, basically. I mean, on the face of that alone, that's gonna survive. I can't see the judge. I can't see any right-minded judge dismissing that, because that's just wild on its face. I can't see any judge dismissing statement 12. Anyway, let's go and see what the judge's decision is regarding this statement. Let's see. So it falls under substantially true as well as hyperbole and an opinion. So let's go ahead and read it. It says statement 12 is the quote from Young that Jacob leaked nude photographs of him and sent them to business partners, roommates, and potential investors, calling him unprofessional. The defendants argue that plaintiffs have confirmed that Jacob had informed. The defendants argue that the plaintiffs have confirmed that Jacob informed a third party of Young nudes, rendering the quote true. That's weak, to be honest. However, the plaintiffs stated pre-publication that Jacob informed an internal consultant under an NDA of pictures' existence, but did not leak the photos. Such behavior is far from the behavior described in Young's quote. Like I said, it just doesn't, like that the reason that she gave was so weak. According to statement 12, it's not substantially true and must be analyzed as to the remaining defamation elements. On its face, it was going to be hard to escape from this one. I mean, this is probably the biggest reason why you should doubt Taylor Lorenz already, because alleging this and then arguing, oh, well, she did say to someone that Ms. Young had news, so therefore it's true. No, come on. You must have you put that in an article. You must know that the impression this gives to any reasonable reader is just wild to read. It was never going to get dismissed. So yeah, let's go back to read the rest of the statements. Statement 13 goes on to read, on June 9th, influencers split from Drip Crib influencer house to over disputes about rent. On his Instagram on his Instagram account, influencers said that members of Drip Club. Okay, let me start again. Statement 13 goes on to read, on June 9, influencers split from the Drip Club influencer house to over disputes about rent. On his Instagram account, influencers said that members of Drip Club breached their contract and failed to pay their share of the rent. The plaintiffs alleged that this statement was false because the falling out had nothing to do with the rent, as a separate article hyperlinked in the article demonstrates that Drip Crib had issues paying the rent to a third party, not plaintiffs. So let's go on and see the judge's decision regarding this. And this is false under substantially true. It says statement 13 is that influences split from Drip Crib over disputes about rent and posted on his Instagram account that members of Drip Crib breached the contract. The defendants argued that the article accurately reported the statements plaintiffs made on their own Instagram account. The plaintiffs have not disputed this argument. The defamation claim is dismissed. I just remembered about statement 12, it being hyperbole and opinion. Let's just go ahead and read that very quickly. It says the defendants also argue that statement 12, young statements regarding the leaked nude photos, are protected opinion. Oh my God! Oh, come on! How is it an opinion? Like it's like Kim K. It's like, let's say Kanye West sues Ray J and says you had sex with my wife on the video, and Ray J responds with, "No, bro, it's not real. It's an opinion. We didn't really leak the nudes. It's just an opinion." Come on. While his statement that Jacob manipulates people and is a nightmare can be characterized as an opinion, the further statements that Jacob leaked his nudes is not opinion, and it can be proven false. Accordingly, statement 12 is actionable. I mean, I'm surprised that they even try to argue this one. I'm really surprised, because so on its face, how do you call a leaked photo an opinion? I'm sorry, what? A leaked nude photo by that respect. Anyway, let's go back to the statements. Statement 14, I believe this is the last one. He goes on to read, Sarah Zila, 46, met Miss Jacob in April when Miss Jacob attended to sign Miss Zila, 16-year-old daughter, Ellie, to a management contract. Miss Zila declined, but soon discovered that Ms. Jacob had already added Ellie to the talent portion of an influencer's marketing deck. Ms. Zila emailed Ms. Jacob and asked her to remove Ellie's name and image from the deck and to stop referring to herself as Ellie's manager. Ellie had heard from a few different notable people to be careful because Jacob will tell everyone that she represents you, and that's exactly what happened. Ms. Zila said, last week, Ms. Zila discovered that Ms. Jacob was telling people that she had a management relationship with Ellie. For any parent to know that someone is out there saying that they're close with your child and they represent them is uncomfortable and unsettling, she said, adding, I didn't hire her for a reason. The plaintiffs alleged that they informed defendants prior to publication that they never presented Zila with a management contract nor used her in a marketing deck, as no such deck existed. Rather, Zila was listed on an informational deck for GIV, which Zila's mother approved of, and from which Zila was removed once Zila's mother's request, which Zila's mother's requested removal. Further, Zila did sign with Jacob on July 31st and 2020. In my opinion, this statement should survive. I cannot see why the judge wouldn't think that this statement would survive. So let's go ahead and read the judge's decisions in regards to this statement. I think it falls under, like, I didn't find it in either no defamation or hyperbole opinion or it's substantially true, but I did find it under actual malice. So we're going to go back and read that. It says the defendants next argued that the plaintiffs has failed to plead actual malice as required by New York's anti-SLAPP law. To allege actual malice, a plaintiff must allege that a statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. Therefore, the critical question is the state of mind of those responsible for the publication, Palin versus New York Times 2019. Therefore, it's Lorenz's state of mind as the author of the article that is relevant. The 5 statements have not yet been dismissed, so I know the statement 14 falls under this. We don't know I don't know the argument for it because I looked and I can't find it. But it says the 5 statements have not yet been dismissed, which is portion of statement 3 that Jacob told Kennedy residents that they would have at large covered the rent. Portion of statement 8 that Jacob promised GIV residents brand deals money and opportunities that never materialized. Portions of statement 9, that Jacob had installed security camera in the kitchen of the GIV house without the resident's consent. Portion of statement 12, that Jacob leaked young nudes to business partners. Again, statement 5. Statement 14, Jacob had made the false representations that she was managing Ellie Zila and had added a name and photograph to the influencer's marketing deck without the mother's permission. The parties do not make arguments as to the actual malice of each individual statement, but rather generally argue about whether the article as a whole published with actual malice. The plaintiffs make 6 arguments to the adequacy of their actual malice allegations. First, they point to the allegation that the article was written with a preconceived narrative. However, the single case that they cite to support Veritas versus New York Times CEO 2021 does not address whether an alleged or of a preconceived narrative is sufficient to allege actual malice. Their second argument is that Lorenz sent them a long list of questions with a quick deadline prior to publication of the article. This is what I was talking about. It was 5 hours, constituting a sham investigation into the details of the article and purposely avoidance of the truth. They cite no cases in support of their argument that allegations of last-minute inquiries prior to publication of an allegedly defamatory article can raise an inference of actual malice. That's all that's required for this stage. Just an inference. It doesn't need to actually be actual malice, if that makes sense. Just an inference. Third, they argue that defendants provided sufficient evidence in their pre-publication responses that would cause a prudent and diligent person to entertain serious doubts about the truth of the allegations. In support of this argument, they cite Palin. They argued the Second Circuit held that the evidence that the writer was aware of contradictory information was sufficient to give rise to a plausible inference of actual malice. However, the Second Circuit only stated that the awareness of contradictory information gave rise to more than one plausible inference. Okay. Further, the pre-publication communications alone simply do not permit the conclusion that the defendant in the fact entertained serious doubts as to the truth of the publication, particularly because Lorenz received contradictory information from multiple other sources and influences. That argument kind of makes sense, because if you are receiving loads of contradictory information, what can you actually do? You're not really the judge and jury or executioner, you're just the reporter. So from that argument, from that face of it, I do understand why this wouldn't be reasonable grounds to infer actual malice, unless it was, from what I'm understanding, I could be wrong, if it was the same contradictory information sent to you. Let's say both parties send you let's say your source, the source that you're gonna write about, who gave you the story, sent you this source and says this is the truth, and then you spoke to Lorenz. And then Lorenz in this case speaks to Ariadna Jacob, and she gave a contradictory information, and then someone else also speaks to Lorenz and she gave a contradictory information that is corroborative of Ariadna, for example. This would be actual malice inference, because she had more than one person to say, look, this is defamatory, this isn't true. But from what I'm seeing, this didn't really happen. It didn't really have multiple people saying this from what the judge has been presented with, I must add. Fourth, the plaintiffs point to the fact that the defendant's use of the record sources for the article, but did not allow the plaintiffs to provide documents in support of their versions of events of the record. Lorenz stating, "I would also welcome any emails, texts, or documents Ms. Jacob is willing to share on the record." In support, plaintiffs cite Heinz Communications Inc. versus Cornerton 1989, in which the Supreme Court stated that circumstantial evidence of departure from accepted journalistic standards would constitute some circumstantial evidence of state of mind relevant to an actual malice inquiry. However, plaintiffs have not sufficiently alleged beyond mere conclusory statements in the instant case that refusing off-the-record documents would in fact be such a departure. Fifth, plaintiffs argue that defendants ignore their pre-publication denials of truth of the allegedly defamatory statements. Sixth, plaintiffs point to their allegation that Lorenz had a personal motivation to disparage plaintiffs due to their status as competitors of UTA, the talent agency that represented Lorenz in a book deal, signed just prior to publication of the article. Heinz it cannot be said that evidence concerning motive never bears any relation to the actual malice inquiry. Overall, the plaintiffs argue that while these factors may not individually lead to an allegation of actual malice, played together they do adequately raise the inference of actual malice. The defendants point out that the denial of the veracity of allegedly defamatory information is not enough, as such denials are so commonplace in the world of polemical change and cannot charge that in themselves. They hardly alert the conscious reporter to the likelihood of error. Publication in the face of denial by plaintiffs of a statement's truth does not demonstrate actual malice. For the same reasons, they argued that their refusal to consider of the record evidence and their delay in reaching out to the plaintiffs for comment pre-publication cannot constitute evidence of actual malice. Further, the defendants argued that failure to verify statements with the plaintiff before publication does not constitute actual malice. Failure to verify statements with the plaintiff and reliance upon biased sources in themselves do not amount to reckless disregard for the truth. I get that point. I mean, but you do have to argue at the same time. I get not reaching out to verify to the plaintiffs. I get, but there must be some kind of verification going on. Just by reading this whole thing off by his face, you can, like, are you verifying from the defendants to opine the authenticity of this? What, like, you know, you may argue, okay, so I get the argument, but you may also consider the other argument is, okay, they may not have reached out to opine the authenticity of some statements, but what if they actually received information during investigation other than reaching out? Would that constitute actual malice then as well? I think that has to be considered. I mean, it's just my take on it. The court agrees none of the plaintiff's allegations regarding the manner or method of verifying statements with the plaintiff's amount to allegation of actual malice. Okay, I get it now. So basically, they do reach out, but it doesn't matter how they do it or the methods in which they're doing it. From what I'm reading here, you know, as long as they reached out, they've reached out, basically. So even if it's 5 hours, 1 hour, etc., they've reached out. Is what I'm gathering here. Additionally, defendants dispute the allegation of an economic motive, as they argue that allegations of improper motives in publishing do not on their own establish actual malice. See R.T. Heinz. A newspaper's motive in publishing a story cannot provide a sufficient basis for finding actual malice. The court agrees with defendants. If anything, Lorenz's behavior in reaching out to plaintiffs prior to publication evinces appropriate regard for the truthfulness of the publication. I mean, come on, Judge. Even if that outrage was conducted only shortly before publication, as a whole, the complaint does not sufficiently allege actual malice as to each of the remaining statements. Accordingly, the motion to dismiss is granted. I mean, okay, fair enough. I mean, if you're gonna say, I mean, fair enough. They're reaching out because, okay. I'm not gonna disagree with that one, because end of the day, yes, on the face, legally, everything that's because the judge has to be legal, has to look at it from that point of view. They reached out. It's truthful. You know, it's not they reached out with questions, it's truthful. So there's nothing there. If they reached out and just say, care to comment, and that's it. But they actually ask questions. So I can see where the judge is coming. It's coming from on this case. But come on. I wish the judge would consider the time frame a little bit, but it is what it is. Defamation by implication. The plaintiffs repeatedly point to the implications and gist of the article in opposition to the defendant's motion. Under New York law, plaintiffs may bring a claim for defamation by implication, which involves false suggestions, impressions, and implication arising from otherwise truthful statements. However, the plaintiffs did not bring account for such a claim against the defendants. And even if they did, the claim would fail. Wow, okay. Sorry, Judge. To survive a motion to dismiss for defamation by implication under New York law, the plaintiff must make rigorous showing that the language of the communication as a whole can be reasonably read both to impart a defamatory inference and to affirmatively suggest that the author intended or endorsed that inference. For the same reason discussed above, the plaintiffs have not made such a showing. Leave to amend. Federal Law of Civil Procedure 15 instructs courts to freely give leave to amend a pleading when justice so requires. The Second Circuit has instructed the courts not to dismiss a complaint without granting a leave to amend at least once when a liberal reading of the complaint gives any indication that a valid claim might be stated. The Second Circuit reaffirmed the liberal spirit of Rule 15 and counsels strongly against the dismissal of claims with prejudice prior to the benefit of a ruling. They highlights the precise defects of those claims. Here, amendment of many of the claims would be futile. The statements dismissed due to being true, lacking defamatory meaning, or being hyperbole or opinion cannot be saved by amendment. However, it is possible that plaintiffs could plead further information to demonstrate actual malice. Accordingly, the court will allow plaintiffs to amend the complaint to further allege actual malice as to the 5 statements identified above in section D4. This is where, if you knew that you can't amend statements, the judge should have taken a bit more care with that labor commission one, because that was a really bad one. And now just by reading this, it cannot be cured. So I'm sorry about that one stings a bit. Conclusion: for the foregoing reasons, the defendant's motion to dismiss is granted. Plaintiffs may file an amended complaint, if at all, by October 5th, 2022. The clerk of court is respectfully directed to terminate the motion. The motion is so ordered. So that is the entire complaint all gone through. Thank you so much for joining me on reading this complaint. There is a reason why Taylor Lorenz deleted a victory lap of a tweet, and we're going to cover that reason in the amended complaint now that has been filed. So do stay tuned for that. We're going to be going through a deep dive and a deep breakdown into that. Thank you so much for tuning in. I hope this wasn't too long. I am going to be doing long form videos, but I don't want to bore you guys, so to speak. I must say that when Ariadna Jacob did file this complaint, she did say that, she did tell me that they didn't think that they had to provide all the information that they did, which makes sense for the amended complaint, because there is a lot of information, there's a lot of evidence in there to even show, look, listen, this is not a frivolous case, so, but the fact that 5 statements did survive out of 14 is quite remarkable. So just by looking at that alone, it does suggest this is not a frivolous suit, because the 5 statements that did survive were very defamatory, especially in the new photos, and especially the promises of brand deals, for example. Let's not forget the new photos like that. If any complaint should survive, it would have been that. But anyway, thank you so much for tuning in. even if you like this video and didn't like this video, I appreciate you for watching all the way to the end. If you did, thank you so much for taking time out of your day. Don't forget to like this video, don't forget to share this video with your friends on social media, and also don't forget to subscribe onto the channel for future videos that I got coming up. Thank you so much for tuning in. The next video that I'm working on right now is the amended complaint and also the declarations accompanying it. Do stay tuned for that. I will be releasing the videos for that. Once